Hi everyone, welcome to Creditor Watch's latest webinar. Today we'll be talking about navigating Safe Harbour, and of course we've got a fantastic guest with us in Ginette Muller, who some of you have probably heard before through our webinar series on all things insolvency, Safe Harbour, plenty happening at the moment. So I'll introduce her in a second. Most people are coming online, but I will kick off now. Creditor Watch, of course, is a commercial credit reporting bureau operating in Australia. We've got a beautiful suite of products from online application in Apply Easy, helping you acquire and onboard customers online rather than using a paper-based application form. Everything to do with credit reporting, director due diligence, look at the directors behind a business, sole traders, are they bankrupt? Do they have any adverse? Payment predictors. We've got a brand new credit score called the Creditor Watch Risk Score that we launched just a couple of weeks ago. It's going gangbusters. Encourage you to have a look at it, have a play with it if you're a customer, or chat to us if you want to find out more. And a whole other suite of products that we're not here to talk about today, so I will keep going. Some key highlights, of course, dozens of public, private and government data sources that we access to create all of these beautiful products. And of course, the credit reports, scores, predictor. We've got well over 50,000 customers, huge number of reports being sold every year. And of course, some other unique data points there, important ones being the Xero and MYOB integration that we have, the only bureau in Australia that has that. Now, I'd like to introduce you to Ginette, who has joined us before. Ginette's a partner at Chadwick, Brisbane, and she is our specialist when it comes to insolvency, but she is one of Australia's leading specialists when it comes to Safe Harbour, which is, if you've been living under a rock, it's actually quite a big deal at the moment, and that is going to be ultimately what she talks about today. You can see here, if you need to contact her, I'll give you the opportunity at the end to actually indicate, yes, I'd love to have a chat to Ginette. It's a good opportunity for people to have that discussion. But without further ado, I think the most important thing we do is kick off. And ultimately, the important question for me to ask to really set you off, Ginette, is what is Safe Harbour? What is all of this about? Can you take us through it?
Well, firstly, hello everyone, and thanks again, Creditor Watch and Patrick, for having me here today to talk about my favourite topic, Safe Harbour. So yes, well, I will get to what Safe Harbour is, but I thought I'd just give a bit of an outline of what we're going to talk about today. So it's going to be a bit high level, but any discussion about Safe Harbour has to start with insolvent trading, and then I'd like to move on to a discussion between what's real Safe Harbour and what's COVID Safe Harbour. So we're going to talk a little bit about that. And then for something a little different, I thought we might take a look at an example from the real world, a relatively brief summary of a recent case from the Supreme Court of Victoria. Is that case you can see there, Barnes Proprietary Limited, and we'll take a look through that. So let's get started. Let's move on to the next slide if we could, please, Pat.
Just really quickly, what I forgot, of course, everyone, please, I encourage you to ask questions. We will have time at the end. So if you want to ask questions, there's the opportunity to do that within the GoToWebinar control panel. Fill that question out and hopefully we get to it at the end. And if we don't, we will get back to you, I promise. Over to you.
Thanks. All right, so to talk about Safe Harbour, as I mentioned, we have to look at insolvent trading, because Safe Harbour is ultimately a protection against insolvent trading. So it only applies to companies, because only companies can be accused of insolvent trading. So it all forms part of what are directors' duties, and you can have a look in section 588G of the Corporations Act. You'll find the duty there for directors to prevent the company from incurring debts when the company is insolvent. And then if you're found to have breached that section, then effectively the corporate veil of the company gets lifted, and that protection, or the whole reason of why you wanted to be in a corporate entity to sort of protect your family and your personal wealth, etc., from that additional risk gets wiped away, and you'll be held potentially liable for any of the corporation's debts. And there are defences, of course, to this, and this of course only happens in the event of liquidation. And one of those defences is safe harbour. Essentially, it's actually a carve out. It's not a true defence in the true legal meaning of the word, but for our purposes and for today, we'll just treat it as if it is a defence, and we'll have a closer drill down in relation to that. Next slide, please, Pat. Okay, so prior to the government introducing COVID Safe Harbour, which we'll talk about in a minute, in 2017, the government introduced what I've referred to as real safe harbour. It's not actually a term, it's just referred to as safe harbour, but I think it's just easier to call it real safe harbour so we can differentiate between the two. So how do you access real or fully compliant safe harbour? We need to have a look at section 588 GA of the Corporations Act. And this type of safe harbour requires directors to satisfy a process. And once that process is in place, safe harbour commences. And in summary, that is when there's a turnaround plan, and that plan must result in a better outcome than if you were to liquidate the company. Employee entitlements, including superannuation, must be up to date, and BAS and other lodgements must be up to date. And once in safe harbour, the directors are required to ensure that A, officers and employees are not engaged in misconduct, and that the company continues to keep accurate financial information, and that the directors are getting advice from an appropriately qualified professional. So it's pretty quick, and I think some of these key points will sort of be covered when we go through the case study. So don't worry if I was a bit fast with it, a bit fast and loose, but we will get to the key points, Pat.
Can I put you on the spot just quickly and ask, was how extensively used was real safe harbour, pre-COVID? I speak to a lot of directors, a lot of companies, and a lot of them had no idea it really existed. Was it something that was used a lot, not at all? Could you put a sort of some sort of measurable against it?
Not really. It's really difficult to say, and there have been a number of surveys, and it really depends who you ask. The main reason for that is because it's not recorded. Unlike a liquidation or a voluntary admission where you have to report it to ASIC, you can have some statistics. So really all you have is anecdotal evidence in relation to what advisors or people like myself are prepared to sort of fill in questionnaires or surveys, because ultimately it's confidential, and a lot of times you may never find that someone's been in safe harbour because they might have had an issue in their company's lifespan, and they might have decided to jump into safe harbour, and they might be out of safe harbour and nothing might have ever happened. So yeah, look, it's difficult to say, but myself, I've conducted a number of safe harbours, and I continue to do so.
Thanks for that.
No problem. All right, so as I mentioned earlier, there are two types of safe harbour. We've already discussed what real safe harbour looks like. So as I mentioned, that was available since 2017 and continues to be available to this day. COVID Safe Harbour, on the other hand, was introduced at the height of the coronavirus pandemic, and it was part of the government's economic response to dealing with the issues that we all had to face in March. And it got extended. It's been extended till the 31st of December. And what it means is that you don't have to comply with any of those matters that I previously identified. For example, you don't have to have a plan. You don't have to have your employee entitlements paid up to date. You don't have to have lodged your BASs or your tax returns, etc. So it's a really good way of protection, an additional protection that the government gave, along with a number of other sort of responses, including JobKeeper and the extension of stat demands and all those sort of things. I think you've got a question, Pat. I can see you shaking. No?
I do. but I'll come to it. I'll let you keep in your groove, and I'll save it for the end.
Sure. No problem. All right, so combined with the two streams, we've also got this scenario at the moment where there's some new legislation. I mean, it's been the year of legislation, my goodness me, where the government is now looking at introducing some insolvency reforms for what they refer to as, some reforms in relation to smaller companies. So the sort of what would be a smaller company? Well, they're saying less than $1 million in creditors is sort of the benchmark. And this legislation is due to be introduced or due to be available to the business community from the 1st of January 2021. Now, what this could do to Safe Harbour is extended out to this COVID Safe Harbour, is potentially extended out to the 31st of July. I mean, that's a hypothetical. Because what it seems to be is that in January, between January and possibly as late as April, depending on a business's circumstances and their access to advisors, they would be able to indicate that they're considering getting in touch with an advisor, and that their company may be becoming insolvent within the next 3 months. It may either be insolvent or about to become insolvent in the next 3 months. So they effectively have to put their hand up and say, hey, we possibly fit into this, we fit into this category, and they would then have to notify ASIC within a certain period of time. Some sort of notification, which we're still to find out about that, would have to occur. And then they would have to go through a process of perhaps entering into what we're going to refer to at this point as a VA light. But it's anticipated that during that period up to when they raise their hand and go into some form of restructuring, that they would continue to have access to this COVID Safe Harbour.
And a lot of these details are still to be worked out, and it's being worked out almost in real time at the moment, isn't it?
It is. It's I think, what's the date today? Yes, I think today is the last day to comment on this piece of legislation that's before a Parliament. Well, certainly in terms of the regulations and the rules that have recently been released. So yeah, I imagine it'll be in place by December. Yeah, watch this space, exactly. All right, next slide. Okay, so I'm hoping that a lot of what I've mentioned earlier may make sense if we look at a real life case. And this is the case of Barnes Proprietary Limited in liquidation, a recent case, as I said, out of the Supreme Court of Victoria, only delivered on the 7th of October. So I'd like to start at the end by reading paragraph 141 of Associate Justice Randall's judgment. I'm saddened that Mr. and Mrs. P find themselves in the position they are now in. It is clear that Mrs. P was motivated to found the business of the company and to continue to provide employment for her disabled son, who now resides with them and their grandchild in modest accommodation when compared to their former Williamstown residence. Both Mr. and Mrs. P are now pensioners. I also note that Mr. and Mrs. P lost 3 properties and their superannuation funds to prop up the company's operations. So with that, let's move on to the facts. The facts of the case are as follows. Mr. and Mrs. Patch, or I'll refer to them as Mr. and Mrs. P, were the directors of a company which ran 2 separate cafes in Melbourne. The tax office served a stat demand on the company in July 2012, claiming $108,000. In November 2012, following the ATO's application to wind up the company, the directors appointed a voluntary administrator. Despite the VA appointment, the tax office persevered with their winding up and appointed their own liquidator in December of that year. I'll spare you the many pages in between, but the gist of the matter was this. The liquidator sued the directors for insolvent trading, claiming that the ATO liability had been incurred over a 3-year period when the company had been insolvent. The claim was for $108,000. And it's worth noting that there were limited third-party creditors in this matter. The liquidator proved insolvency by reference to outstanding activity statements, outstanding POAG withholding summaries, failure to lodge income tax returns, and a handful of small judgments against the company. In addition, the company had woeful records, and the judgment reflects that. Because of this, the liquidator was able to succeed in a claim for deemed insolvency. Ultimately, however, the directors could not prove solvency, and so actual insolvency was also proved by the liquidator. Having determined the company was insolvent and the company had incurred the tax liabilities during the period of that insolvency, His Honour then looked to whether Mr. and Mrs. P had any defences. Other than Safe Harbour, Section 588 capital H of the Corporations Law also sets out other available defences, including that as a director, you had reasonable grounds to believe the company was solvent. Mrs. P argued this defence. She refuted completely that the company at any time traded while insolvent. Had there been a requirement for cash advances, then she claimed the directors would have made funds available through either the sale of property or by raising finance against the equity in the property. The judgment then looked at a number of cases on this point before acknowledging that if there is sufficient evidence that a company can obtain voluntary funds from a third party, then it can establish solvency, but there needs to be a sufficient degree of commitment in providing financial support to the company such that the company can pay its debts as they fall due. However, in this case, Mr. and Mrs. P needed to provide evidence that they had a sufficient degree of commitment to advancing funds to the company. Mrs. P claimed a willingness, but that was inconsistent with her conduct. And this is noted in light of Mrs. P contending that the equity in the property was extensive, over $519,000, and could have been accessed if required. In summary, it's easy to say on this point that if you have the capacity or had the capacity and the intention to pay, why didn't you? Next, His Honour examined Mrs. P's claim of Safe Harbour. Mrs. P submitted that the appointment of an advisor, together with her attempts to put together a plan that has a chance of putting the company in a better position, was Safe Harbour. In relation to her claim, His Honour noted the following. There was no engagement letter from the advisor. The ATO debts were incurred prior to the implementation of any course of action. There was a failure to pay the entitlements of the employees, that's the superannuation guarantee amount. The company had not complied with the obligations to provide returns to the ATO. The action taken to appoint administrators was merely to seek to stave off the application for the winding up. For these reasons, Mrs. P's claim that she should be afforded the protection of Safe Harbour failed completely. Before summing up, His Honour noted that the court has discretion to excuse directors for insolvent trading, but in not excusing Mr. and Mrs. P, he noted the following. A, Mr. Patch did not concern himself to discharge his duties. He was really an absent director with no involvement in the management of the company. Mrs. P failed to ensure that the records of the company were properly maintained, and in particular failed to lodge returns required by the ATO. There was a failure to comply with requests by the ATO to lodge returns. Mrs. P failed to ensure that the ATO assessments were met. She failed to investigate the possibility of raising finance to meet the ATO liability. And she failed to ensure that the company paid its liability on receipt of the stat demand or to negotiate with the ATO to come to any sort of arrangement. It goes on. They were eventually found guilty of insolvent trading, and as you can see from the slide, were ordered to pay a substantial amount of money. So what's the takeaway of this? In my view, the judge was sympathetic yet annoyed. Had Mrs. P been able to produce an engagement letter, maybe some of that fury could have been directed to the advisors. Who knows? What it shows to me, however, is that Safe Harbour is more than a mere cobbling together of hopes and post-justification of possible plans. Real Safe Harbour is as serious and as compliance orientated as keeping proper books and records. Anyone who decides to enter Safe Harbour needs to remember the following. Pick an advisor who is reputable. Get an engagement letter. Make sure the advisor has insurance. Make sure they confirm in writing that you are in Safe Harbour. Make sure it's part of their engagement that they will assist you in meeting the evidentiary burden of proving Safe Harbour. I'll finish here so we have time for some questions, Pat. Look, on that case, I think that, it's really easy to search. If anyone wants to read a little bit more, it is quite interesting. You just type that into Ostley in the whole 150 paragraphs will come up for you.
Yeah, and that's AUSTLII, isn't it?
It is. You're right. Yes.
Yeah. Sorry, still going, Ginette? I've got a question for you.
No. Look, that's it. Please fire away.
I appreciate that. Thank you. And of course, we will share these slides with everyone as well, so you'll have the ability to sort of refer back to it in the future. I guess the big question that I get asked a lot is, you know, do you think there'll be an extension of the COVID Safe Harbour from the 31st of December, or you know, what's your expectation? And I might go first just to get my view out of the way, if that's all right. I'm of the opinion they will extend it, and I think I've softened on this in the last month, but I still get the feeling that the government won't necessarily have the numbers, sort of economic numbers, to support a hard stop at the end of December, particularly out of Victoria. And then obviously, you know, I think SA, the real small lockdown will still have a bit of an effect on GDP. However, I have certainly softened on this, but yeah, very keen to get your views.
Yes, and so when you say an extension of the Safe Harbour, do you mean an extension of COVID Safe Harbour for everyone or for the SMEs?
So I think, I don't know, I get the feeling they'll struggle to. I think the only way they could extend it for a chosen select few is if they said, okay, you know, if you've got liabilities under $1 million, and they sort of link it in with that new insolvency. But new insolvency, you know, rules for SMEs. I'm keen for however you want to answer that, or if you want to have a couple of answers to it.
I think that it will be extended for, you know, that small category, as we say, although it's actually quite a large category. I don't have the exact numbers here, but I think it represents quite a significant number of businesses that meet that criteria. So companies that have liabilities less than $1 million, and that would include secured creditor liabilities as well as unsecured liabilities, but certainly not contingent liabilities or future liabilities like rent, etc., that's not yet due, then those entities, subject to them taking these steps, as I mentioned earlier, of putting up their hand at some point in the next 4 months up till April, will get some extension of the temporary safe harbour. So that's already pretty much on the cards. Those people equally will also get an extension in terms of the other reliefs, which is that they won't be able to be, they won't have to meet a statutory demand that expires within 21 days. They'll have 6 months. People have to give them the 6-month extension. So I think that's definitely going to happen. I sort of think that the government,
the sort of blanket safe harbour, COVID safe harbour will be gone.
I think
where
so.
they don't have to interact with an advisor, so to speak. That'll be gone, and have to sort of move towards a more traditional safe harbour combined with the SME.
I think that's going to be there. You're going to have to go and get proper advice. And I think for the other parties that that won't get the blanket safe harbour, well, they're larger entities, and they need to start taking matters into their own hands, and they need to go and seek proper advice, and they can't hide under the blanket for much longer, really.
And utilize the real safe harbour. Yeah.
Correct. If it's required. I mean, there's a lot of businesses that are going really well, and there's certainly been some winners and some losers in the last 9 months, and it's not necessarily doom and gloom for every single business.
Yep, great. The other thing I wanted to ask was, do you get a feeling that businesses are, doing much better than they were, say, in September? As a whole, I know it's a tough question, but you would speak to a lot of directors and have a lot of insight into the the insolvency space. It's certainly, we know from administration numbers on a monthly basis, they're still at record lows. You know, would you say the majority of businesses are sort of getting back to, you know, pre-COVID levels, or at least manageable COVID levels?
Yeah, look, it's difficult to say. I would think that there's a number of issues that are keeping insolvency numbers low, and some of that would have to do with the fact that
Sorry.
you know, we've got it's okay. We've got good support from the banks at the moment. They're talking to their customers and they're giving them relief as and when required. The tax office is being very reasonable too. I've heard some incredible stories about the willingness to enter into some pretty lengthy repayment arrangements. There's also, you know, still businesses who are receiving support from the government in terms of JobKeeper. In a number of states, Queensland in particular, our you know, residential housing market is still ticking along quite nicely. And as we know, a lot of companies use the equity in their properties, similar to Mr. and Mrs. Patch in our example, to support their businesses. They can pay off some of their debt during the good times, and in the more difficult times, they tap into that equity, as is their right as a small business, or anyone is entitled to do that, of course. So, you know, there's, and of course, at the moment, we've got low interest rates. So I think the conditions are relatively good. What's not going so great for everyone, I suppose, is the problem that, you know, we have a little bit of knee-jerk reaction in terms of lockdowns, and that can sort of, you know, impact upon a business's confidence in terms of, you know, can I rely on opening today? Can I rely on the longevity of whatever it is that I'm in, that I do? So each business
it doesn't encourage investment, does it? We've got to remember that a business can't just sort of turn the engine on and off, start up and stop.
Yeah, so I think those that you have to weigh those things up. So conditions are good. Will the government throw something else out in the new year to incentivise businesses to have a go, to put those issues behind them and say, look, it's worth the risk now? We don't know. I hope so. I mean, you know, we need it all to happen to get back to where we were and move forward.
Thank you. We've got plenty of questions that have come in, so I will I'll ask the hard ones for you rather than give you the soft ones. No, I'm kidding. A good one here that I have seen come up a few times and have been asked about myself is, what is considered a qualified, you know, advisor or consultant from a Safe Harbour perspective?
Okay, well, there's no case on this at the moment, unfortunately. But I suppose when you contrast it with the case that I've just explained, I think that a court would expect that the appropriately qualified entity or the person would at least be able to advise the directors in this case what their options were, that they were insolvent, that they had been insolvent for a period of time, and you know, have had some experience in this area. So I doubt
it's a better look using a qualified accountant, insolvency practitioner, or you saying maybe not even the accountant, maybe more insolvency practitioner, obviously putting bias aside.
Well, I would say that would represent. But absolutely,
but that makes sense, right?
Yeah, I don't think you'd have, Mr. and Mrs. Patch would have had any problem if they'd had a properly signed engagement letter from an insolvency practitioner who'd set out that they were in Safe Harbour. But as it turns out, of course, that person would have said to them, well, you can't be in Safe Harbour. You can't be in Safe Harbour because all of these things, you're non-compliant. So what you probably need to do is you need to either use some of the equity in your house, which they did do anyway, but they lost the whole lot. They lost more than $100,000, which was what the debt was, to try to sort through this issue. So appropriately qualified entity, I'd say, I would get someone who's got some insolvency expertise, and watch this space, because I imagine we're going to see a lot more of these types of judgments coming through.
Yeah, and that might be, they might end up actually defining what a qualified consultant or advisor is in time.
Yes.
It has been discussed, as I understand.
Well, look, exactly, and there is guidance in the explanatory memorandum. There's some guidance in that each different business will require a different level of expertise. Sometimes it will be an insolvency practitioner. Sometimes, you know, in the case of a publicly listed entity with many subsidiaries, it might be a combination of people. It might be the lawyers and an insolvency practitioner. Who knows?
Yeah. If directors are concerned now that they're insolvent, or they know that they're insolvent, should they be waiting to find out whether this extension occurs, or should best to engage someone immediately, right? It seems to me it would be best to engage immediately, because hopefully that advisor actually helps you trade out of being insolvent and gets you back onto a path, whereas waiting too long, burying your head in the sand, is certainly probably the worst thing you can do.
I think that's absolutely right, and the judge even refers to Mrs. P in that case of burying her head in the sand, and that there was a lot of that. I feel some sympathy for her. How does she know what advice she's looking for? I mean, it's such a specialised and complex area, this area that we're discussing at the moment. So look, is it really going to hurt to go and get some advice? Is it, you know, to consider what your options are? You don't have to follow that if you don't want to, but I think to actually hear the options and understand what the risks are that you're taking at this point in time, I think that makes a lot of sense to me, particularly when you've got this deadline looming as at the 31st of December.
Yeah. Good question here. Paying high charging advisors to implement Safe Harbour seems counterintuitive.
Yeah. So, all right, it's always the fees, isn't it? My answer to this is quite simply, there are advisors who just do the compliance side. That a lot of times where the expense will be with respect to a turnaround is in that the advisor might actually come up with the plan. They might be heavily involved. They might have a lot of staff involved in quite a substantial amount of your business, including the plan, which can be quite extensive. So a lot of companies are actually quite capable of coming up with their own plan, are quite capable of implementing that plan and reporting to someone like myself, who really is just there to do a compliance check and to actually pull together the evidentiary burden, I call it, so that, you know, in 12 months' time, if in the unfortunate event you end up in liquidation or voluntary administration, whatever happens, you didn't plan to be there, but it happened. What you need to be able to say to your liquidator or to whoever's, or hopefully it won't get to court, is, hey, look, we did all, we had a plan, here it is. We engaged someone, here's that. And we were really good with our corporate governance. We had monthly meetings, we matched, we checked the plan, we measured it, and here's all of this. And by the way, you know, here's our advisor, talk to her. She should take the heat, because after all, we were doing this. Now, I think that type of appointment is not going to cost a fortune. It really shouldn't. And I think that if every time you go and look for a consultant who's going to charge you a fortune to do that, well, then you need to just keep calling and checking and find the right consultant who can give you the right advice. I mean, it's not easy, I admit.
Yeah. Are you expecting? So there's a question here which we can kind of answer the question, but then do a different answer with it. Do you expect a large amount of notifications to ASIC in early 2021 for companies entering Safe Harbour? I'll answer that by saying there isn't a register for Safe Harbour, so we won't get Safe Harbour notifications. However, from an ASIC perspective, it's certainly very possible that we will see a large increase in administration appointments or liquidations and anything associated with that, right?
I mean, they have to publish on the ASIC notices website, so you'll record those, won't you? They go onto your system.
Yeah.
Yeah.
That's right.
So,
yeah, anything through the public notices will come through, and anything that's lodged by a liquidator or administrator as an ASIC document, and then also any sort of status change as well. We'll see, and I'm expecting an increase in December. I think people will get to December and go, regardless of whether they extend, we're gonna opt out of this now.
yeah, look, I think there will be a number of notifications in the new year. Certainly, the notices, we haven't even seen the form yet, what that might look like. How do you advertise? Because what is actually envisaged is that the directors do this advertisement, not a liquidator, because a liquidator has not yet been appointed. So maybe there'll be on a company's portal, there'll be a ticker box, and you can go in there and you can self-report. I don't know. It's a bit of work for ASIC to do, I imagine, to sort of tell us.
And they are actually, in their defence, they are on the front foot with this. They're working on it. So we've been in contact, or they've been in contact with us, so that they can start to communicate that, which is good. Now, it doesn't matter how big or small a company is regarding Safe Harbour. However, within a company, keeping in mind that a big chunk of our customers and attendees today are likely in credit or AR roles. What sort of role does someone in accounts receivable, accounts payable, finance, even if they're not a director, what sort of role do they play?
Sorry, do you mean if they are working
from a
for the company?
Perspective? Yeah, should providing advice to the director or the MD or someone like that.
If you're having, so for example, if you know of a person who's struggling with paying,
I think more so within your own. I think more so within your own company. There's obviously nothing. You're not liable, but there's the ability to see, hey, this doesn't look good. Are you familiar with, particularly in small businesses? Small business owners aren't experts in insolvency law. Some of them they'll be signed in here, but I think there's an opportunity for those in AR, AP, finance to provide that advice to directors or the owners to say, hey, I know we're in trouble. I see it.
Yeah.
Have you heard about Safe Harbour?
Yeah, look, and again, it's one of the main reasons why I wanted to highlight this particular case, because it's not a big amount of liability, and yet these people lost a lot, their life saving essentially, and they didn't even think they were doing the wrong thing in any way, shape or form. So I think that the first thing to remember is that directors are the ones that are personally liable. The directors are the ones that are in control, and it's their responsibility. But as employees, be careful. Don't be overstepping the mark. Don't be taking on that shadow director role. That's not your role. Hopefully, you're not getting paid for it. It can be quite risky. So make sure you know what you're getting into. And if you want to take on that role, I'd say make sure you're being rewarded appropriately for it, for the risk that attaches to being the director of the company. Mm-hmm.
Yeah. Look, there's plenty of questions coming through, and what I'm going to do, I'm going to put up a quick poll that allows you to essentially say yes or no. I would like to be contacted. Sorry, I'm not sure if I cut out there, but
no, I can see the.
There we go.
Yeah.
If you're just worried about time here, and I'm conscious of people wanting to get back to work or have lunch before they go back to work, so I think this is a good way for us to find anyone who does want to be contacted. And it says by Creditor Watch, but that can be by Creditor Watch / Ginette. Creditor Watch will be the first point of call, and then if we need to pass you over to Ginette, obviously we can do that. So please indicate yes or no. You don't even have to indicate no. Yes is the most important one here. And then the other questions we'll be able to address, most likely in a follow-up article to this, a blog article. I know that we're quite keen to do that because it is such a hot topic at the moment. We will do that, but then for those that might be a little bit more technical, we will endeavour, of course, to get in contact with you. That brings us to the end. Ginette, was there anything else that you wanted to finish up with? We've obviously got through plenty today, which is good,
Yes.
and I don't think it'll be the last time we talk about it.
No, look, once again, thanks very much for having me. If anyone's got any questions, feel free to drop me a line. Thanks, Pat.
Yeah, no problem. We'll obviously share Ginette's details as well in the follow-up email. If you've indicated yes, you want to be contacted, we'll work out whether you want to speak to us at Creditor Watch or the expert that we have with us here, and Ginette. Ginette, thanks again for joining us. Super informative and helpful as always. Everyone else, thanks for joining too. I hope you enjoyed it. I hope you got something out of it. Don't be shy to join us in the future or to reach out if you didn't get your question answered and for some reason we didn't get back to you. Until next time, thanks very much and have a safe week.